by demonizing a group of lawyers who are trying to defend small businessmen, basically small inventors. Proponents of this legislation are demonizing patent lawyers to draw attention away from the fact that they have stolen someone else's patent-protected technology. Now the big guys want to change this so they can get away with the theft. That's what H.R. 3309 is all about, and that's why it should be called the Anti-Innovation Act. It is an aggressive attack on the ability of inventors to defend their ownership rights to the technology they have invented. It is not about frivolous lawsuits or trolls. That is a cynical cover for, that is being used and was created by the big guys as a license to steal from the little guys. The former Patent Office Director, Kapos, and other former directors of the Patent Office have made it clear that we should move slowly about this type of change and with great care when we're making such major changes in the patent law. This legislation is too broad, its implications are unclear, the effect unknowable. And that's what witnesses and other experts have indicated. They conclude, move forward with caution. So I would be asking my colleagues, vote against this bill, but if we can, let's ask our leadership, as I have pleaded with our leadership, postpone this so we can talk to our educators, talk to the universities, talk to the various employers in our district, talk to the various people who depend on technology and technology development in our country, rather than just go with a mega multinational electronics companies that are guilty of infringement cases as well as antitrust cases. That is not happening. Congress is being railroaded into passing this legislation right on top of the last legislation. Well, what's going on here? As I say, it's a heavy-handed attempt by mega multinational corporations to diminish the viability of America's patent system. It's been going on this way, and I've seen this for 25 years. Patent protection has been one of America's greatest assets. It's written into our Constitution. It's the thing that has given us the ability to have high wages, yet be competitive with other societies. It's protected the security of our country and our liberty. That's what strong patent protection has been to us. But according to the sponsors of H.R. 3309, this isn't really something about undermining the patent system. No, it's undermining the trolls, just by the fact that everything that they're doing has a major impact on the ability of lawful inventors to protect themselves against infringement, and it diminishes the patent protection that we have had traditionally in this country. Every provision. Well, what does it do? For the most part, this legislation will make it much more complicated, costly, and challenging to bring a lawsuit against an infringer. The little guy is going to cost him much more to protect his rights. Well, there you go. These people would like to restrict lawsuits that are totally legitimate to control a few people who have manipulated the system and thus are abusive lawsuits. Well, we face this all over. Lawyers, there are many lawyers who are engaged in abusive lawsuits, and they shouldn't be filing them, but they do. Does that mean that we are going to dramatically limit the rights of the American people to litigate when their rights have been violated by someone else, their property's been taken, or they have been abused and they deserve compensation? No, we're not going to limit those rights, but we will limit the rights of the small inventor and let these big mega corporations take what they want from what this person has invented and not give them compensation for it, rather than making it simpler, cheaper, and easier to defend against baseless accusations of infringement, and there are some baseless. And what we've done to reduce spurious lawsuits, all we need to do is strengthen the good guys. But this bill weakens the good guys. It weakens ordinary people who are actually contributing a great deal to our country, the independent inventors. In addition, under the claim of technical correction, this legislation proposes the removal of the patent system's only independent judicial review process. Section 145 of Title 35 in this legislation, if it is enacted, inventors who who really believe they have not been treated well and treated fairly by the patent office. I mean, there may be people in the patent office who want to go to work for some major corporation if they decide a certain way, and what they have done, maybe it's not legal. Maybe these things happen in every society, and we need to have a review. In fact, since 1836, American inventors have had the right, if they feel the patent office has not dealt with them in a legal way, they have a right to seek independent judicial review. And that right was, by the way, that right was reaffirmed last year by the Supreme Court in Campos versus Hyatt, which reaffirmed the importance of that review to maintaining the rights of our inventors. Well, this bill would eliminate that right. It just takes it away, something that's been the right of American inventors since 1836. I would suggest that I have a quote here that I'm submitting for the record from Mr. Lamar Smith, chairman of the Science Committee. I would ask permission to insert it in the record at this point.
Without objection.
And in it, he goes into how important it is to have judicial review, and that Americans understand how important that is, that bureaucrats, but they have a judicial review of what their government officials are doing and how important that is to our freedom. Well, I would say, yes, Mr. Smith, I agree. He's the chairman of my committee, the Science Committee. I am the vice chairman of the Science Committee. We disagree on this bill, but I will say that this is an important part of the bill, and H.R. 3309 would eliminate the ability for the court to review what these government officials are doing in their job if they hurt another individual. Mr. Smith thinks that's important when it comes to the environment. I think it's important for the environment and for protecting our inventors. This principle applies just as certainly, as I say, to patent review as it does to environmental regulations. Now the patent office officials have requested, of course, that they don't want to have that judicial review. Why is it? Because they say it's too burdensome. Never mind that very few really people have such claims, but we're going to eliminate that right and that option because it's inconvenient for our bureaucracy. That's absurd, and for that reason alone, this bill should be defeated. The legislation going before the House this week is consistent with a decades-long war being waged on America's independent inventors. Here are a few of the provisions of the bill. It will create more paperwork. When an inventor has to file an infringement claim, it dramatically increases the paperwork necessary to him to file the claim, and thus it's not only more expensive, but increases the possibility that his claim will just be denied out of some technical mistake in the paperwork. The Innovation Act will switch us to a loser pay system. Now, of course, loser pay sounds pretty good. That means if you file a bad suit or something, or you lose a suit, the loser is going to pay the legal expenses for the winner. Do when you have little guy versus big guy, the small inventor versus the mega multi-billion-dollar international corporation. What it does is say, if a little guy sues the corporation and loses, that is nothing. Paying his legal expenses are absolutely nothing for this big corporation. But if he loses to the corporation, that corporation will have piled on legal expenses that will destroy the economic viability of that small inventor. It's no little guy versus big guy. In this case, making it loser pays is a big advantage to the big guy at the expense of the little guy. So the court, and what's unfortunate, this bill goes even further than that. This bill will allow the court to bring others into the case as plaintiffs if they have an interest in the patent. So if someone has invested in the person's patent, in the little guy's patent, if they've invested in it and they lose a lawsuit trying to enforce their rights to have a compensation for the use of what they've invented, well, if they lose that suit, the person who is invested with the little guy, he's going to be liable for this massive bill that these big companies are bound to pile on. So this basically loser pays system has some attraction, but in the